And I always say to people, look, in order to get registered as a trademark, it has to be what's called inherently distinctive. So there has to be something about it that's unique. So don't use anything descriptive. If it's what are you and what do you do or sell, it'll be too descriptive and you won't achieve trademark registration. So make sure it's a bit quirky. Once you know you've got a quirky one, you can register even if you're not trading. So you can file your application, and so long as at the time of you filing your application, you are using or you intend to use your mark, the application will be allowed.
Do you want to earn more? Work less and enjoy what you do each day. It's no secret, it can be done. This podcast with Dr. T will not only educate and inspire you, it will also teach you how to do more and be more with the time you already have. It will be like a shot of adrenaline straight into the heart of your business. Here is your host, Tyson Franklin.
Hi, I'm Tyson Franklin and welcome to this week's episode of It's No Secret with Dr. T. Now today, I have someone by the name of Donna Patane, and she is a highly qualified lawyer and she's also a registered trademarks attorney. And that's what we're going to talk about today is trademarks and how it applies to small business. Donna, how you doing?
I'm not too bad, Tyson. How are you?
I'm doing very well, and I've been looking forward to this talk because I've seen you do a presentation, and I've seen you do it twice, and each time I learned something every single time about trademarks and and why small business people need to know more about trademarks. So what is it? What is it, this whole trademark thing? What's the confusion with all this?
Look, I'm going to get all a little bit geeky on you and say I love dealing in the trademarks world, and I love telling small business about it because it's something that perhaps is not at the front of their mind when they're, busy working on their business, but it's something that comes up from time to time. And quite often I find myself giving similar advice to small business owners, and sometimes big business too. So I thought I would kind of capture the issues within the context of don't bring a sword to a gunfight, because that's how I sort of see the different type of naming registrations. And I think it's a sort of, a user-friendly way of describing how the different strengths of the different registrations work. And the title has come from one of, I think, a lot of people's favorite scenes from an Indiana Jones movie, where Indiana Jones is, battling against the baddies in the Middle East, and it's a long battle. It's a really, really long scene, fending off one after the other, and then he comes up against this guy who's got a sword, and he's warming up and flinging the sword around and all the rest of it, and Indiana Jones sort of pauses and then pulls out his gun and shoots the guy dead, and the battle's over. That's kind of similar to what can happen in the world of trademarks, and in that context, I would usually explain that So it's useful to have a sword, but it's not quite as good as the gun. And the gun in this situation is the registered trademark. So that tends to be sort of how fights occur.
So someone who just has a business name and they think, oh, I have a business name, I'm protected, no one can touch me, just a business name alone is pretty much the sword.
Correct, yes.
So, because I know there's going to be people who are listening to this predominantly in United States and Australia. Are the laws covering trademarks and business names pretty similar?
Very similar, yes. Very similar across most of the planet. And some of the issues arise under what's called the first to use rule. So quite often, you find that the trademark will generally defeat a business name registration, except for some teeny quirks within the legislation. And those quirks in terms of first use and deceptive similarity are very similar across most of the Western world. There are a few carve-outs which deal with first to register, and those countries are the likes of primarily China. And that's why you see a lot of disputes with big brands having fights in China, because China has a first to file rule, which means whoever gets on the trademarks register first generally wins, and it's very difficult to overcome those issues. But those are fairly unique to the likes of China and a few other smaller players in the business world.
Okay, so what you're saying is, so if I had a business name and I was the first to use it in Australia, and say I used it for 10 years, I'd built up a really big business, and then somebody went and registered the trademark they saw my business name and went, oh, I like that. I'm going to register as a trademark because I see it's not registered. Does that mean they can stop me using my business name?
It could do, yeah. Generally because, if you're standing opposite one another, in a battlefield holding the gun, you would generally assume the person with the gun has an upper hand to get started. Then you're left with defending rather than enforcing. And in order to defend your position, you would need to show that you had sufficient reputation built up in the marketplace, the specific marketplace that you're dealing, so say Australia, to prevent someone else from having that name. And inevitably, when you try and run that argument, the other person will say, well, if you cared this much about it, why didn't you protect it? And almost inevitably, the sword holder will say, I thought I did because I had registered a business name. So that then leads me to, I suppose, the discussion I have a lot with small business owners in terms of what does that business name registration mean?
Yeah.
And so there's a couple of different ways you can register your business name. And I suppose in ranked order of priority, the first one would be your company name. So your company name is, if you go to register with ASIC, your company, your new legal entity, and you call it, for example, Donna's Dancing Pty Ltd, and you get given an ACN number. So that means I can use that entity to enter into contracts, to employ my employees, and things like that, fairly general business activities. But it doesn't give you any kind of ownership of the name. It just says that's what your company is called on the books.
Okay, so somebody can have a company name, but then somebody else can register a business name exactly the same as that company name.
Yeah, and then someone else can register a trademark. And then there's domain names that come into it as well.
Ooh.
So across the 4 different options, so your company name, your business name, your domain name, and your trademark, you could possibly have the same name held by different entities. And this is because the systems don't talk to each other. So when you go to register a business name, so a business name is used to be state-based legislation, but it rolled over in 2012. That's really your authorization from the government to use to advertise your business using that name. The purpose of that legislation is not to protect you and your business name, it's to protect consumers. So that if consumers have an issue with a particular business, they can do a search and find out who owns that business.
Okay.
So the business name registration is designed for consumers to be able to identify dodgy operators mostly. It doesn't give the business owner any kind of ownership of the name. That's where trademarks come in.
Okay, so the business name registration is just for the consumer to be able to track you down and able to report you if there was a problem.
Yeah, that's the basis of that legislation, that system.
Wow, that's amazing. So, and is that why in every state somebody can register, will have the same business name registered in 5 or 6 different states because it's only really just to identify the business that a consumer is concerned about?
Yeah, and that was actually the issue that sort of bubbled up to the surface in 2012. So previously we had all of the Officers of Fair Trading looking after business name registration. So you'd pay sort of $40 or whatever it is to have your business name on the system for 3 years, and then they send you a renewal and you do it again. So all of those state systems merged in 2012. So they're now on one system altogether. So when people were going to check their names, suddenly they're seeing there is a Donna's Dancing in Perth. And those two had coexisted for so long, but they never come across each other because, well, if it was historical, there wasn't so much internet or social media activity. And when you're checking your state register, you wouldn't see the registers of the other states. So when all of those came together, suddenly everyone's discovering the duplicates in the other states. So that brought to the surface quite a lot of fights.
But it also just proves that the business name really, other than attached to your business and value over a period of time, it gives you zero protection.
Yeah, that's right.
But is a business name more powerful than a company name, or they're about similar value when it comes to protection?
Probably similar value. I would rank the business name slightly higher because it means you've got it on the register where people are actually trading.
Okay.
And when you apply for a business name, ASIC will do a quick search just to make sure there's nothing exactly the same. Or, but for a dot or a comma exactly the same. So it means that at least there has been some possible hold up to notify you then. But there's people assume that the search that gets done by ASIC, that's it. That's all the search you need to do. But unfortunately, ASIC isn't communicating with IP Australia and vice versa. So you would also need to check the trademarks register, which is looked after by IP Australia, to really make sure it's available. And then to really make sure you have protected it, you should be registering on that platform.
Okay, so is that why they say when you're trading under your own name, you don't need to actually register that name because it's easy for people to identify you?
Yes, there is an exemption. If your actual name or your company name is the same as your trading name, you don't need the business name.
And it's all got to do with...
kind of leave you swinging your sword in the dark, kind of, because you still don't have a trademark. And yes, it's possible for someone to register your name as a trademark.
But it's all got to do with just for the consumer, really just to identify who they got the service from. If there's a problem, the government knows who to attack.
That's right.
Wow, I never looked at business names being that way. That was really just a way of identifying a particular business. Nothing more than an identification number. So when it comes to domain names, what's more powerful, a domain name or a trademark?
Trademark, hands down, particularly if you're dealing with the .com.au second level domain or .net.au. Any of those .au extensions, domains, are subject to a set of rules. And those rules say that needs to be your business name or your trading name.
Yeah.
And there is another sort of level that sits above that, which is looked after by the World Intellectual Property Organization and ICANN, which is the institute that looks after the issuance of domain names and numbers. And those have special rules and a dispute procedure for holding domain names. And you can use those dispute procedures or complaints processes if you have a trademark. So if I have a trademark for Donna's Dancing, and someone else goes out and registers a whole bunch of domain names, really just to squat on them, just to annoy me, not necessarily to do anything else.
Yeah.
There are a few avenues that I could take to have those domains either shut down or transferred to me.
So it's possible to do that. But if I had a domain name that was, just say, for example, I had tysonfranklin.com, which I do have. Mm-hmm.
Yep.
And then somebody went and registered my name as a trademark, tysonfranklin.com, because that was their name as well. Could they then take my domain name off me if I've been using it and I've been trading with it? Do I have any protection or am I buggered?
You probably have some protection because you've already got a history of trade and because there is an exemption to trademark infringement for bona fide or honest use of your own name.
Okay.
So I suppose a similar situation happened to Bob Jane. So you remember Bob Jane tyres and the other car stuff that they sold?
Yeah, I was about to sing the jingle for you, but I won't, yeah.
I know, hey? It's memorable. So Bob Jane had left the business. I think there was a falling out of some sort, and his son or some other relative had taken over running it, and it had not gone down in some kind of friendly manner, so Bob Jane had sought to register a trademark for his name and use it that way. And once the business operator found out, they had a fight about it. And the court ended up saying, look, yes, there is an exemption for if you are using your own name bona fide, so honestly, but here you're not. You've done it deliberately after the fact in order to damage the business that you have left, and the trademark registration was refused.
Oh, so Bob Jane wasn't allowed to register his own name?
Correct.
Ooh.
Yeah. I mean, that's because it came from the background of having a big fight, and he's doing it deliberately to try and sabotage, the operators of the business that was continuing.
Okay, so is it like where somebody might see a company that's come into Australia, for example, and they're just, or there's a business that's kicked off and it looks like it's expanding pretty well, and people go out there and deliberately just go and register domain names so they can't get them, and then try and hold them to ransom later to sell it to them?
Yeah. And I think that's big business, seeing the startups and what's going on overseas and then registering that locally in whatever country you're in. And there'll be, slight quirks about who's entitled and whether they are entitled and that kind of thing. And quite often it's easier just to buy the domain or even the trademark off the squatter.
Okay, then going through a legal battle.
In the scheme of things, a small amount.
Yeah. Well, because we all know how cheap lawyers are.
Yeah, they're very expensive. We need, boats and fancy cars.
So I'm a small business owner, and I'm about to start my first business. What's the process that a new person kicking out in business, or someone who's been in business for a while who hasn't really given this any thought, what should they be doing? What's the process they need to actually go through?
That's a great question, Tyson. Love it. And I love to share this answer because it's something that I really want business owners to be empowered to do this process themselves, or at least to get it kick-started. So I would usually suggest if you're an existing business, you could do what's called an IP audit. And it's kind of like a stock take, but of your intangibles, so your business name and other things like that. Whether you're starting afresh or you're doing an audit, 3 or 5 or 10 years after you've commenced trading, you should always start with checking those 4 different systems. So firstly, go to the ASIC website, and it's got a fairly user-friendly search system for you to search company names and business names. So go through there and search your name, and theoretically the only answers that should come up are your business.
Yeah.
Otherwise, you've probably got a problem. Then check the domain system, check out what other domains exist, and don't forget to check the quirks as well. So if you've got a name that sometimes you use, a number instead of a letter, or if you've got different quirky spelling, or if you've got dots or no dots in an acronym, check those little quirks as well, because those sort of peripheral versions are where traffic can get redirected, and you might be losing out, particularly on the internet. So once you've checked ASIC for company names and business names, and then check the domain name system and availability, the next thing is definitely to check the trademarks register. So the trademarks register is on IP Australia's website, and that website has been updated a couple of times over the last few years, but it's not great at user friendliness. So even if you jump on Google and type in ATMOS, ATMOSS, which is the Australian Trademarks Online Search Service, it should take you to the right page. Then you can type in there your business name. Again, do the little quirks that might exist and see what's already on the register. And you can do a similar exercise on the WIPO site, the World Intellectual Property Organization site. And it's got what's called the Global Brand Database. And it's kind of like a search of all of the available trademarks registers of the countries that are signatories to the Madrid Protocol. Most of the big players in the marketplace. So that's where you can get sort of a combined answer. I suggest doing your local one first because it will give you more relevant details, and it will give them to without any excess information. Because if you type things into the global brand database, quite often you'll get thousands of results. So it's easier to just start with the national one first.
So what was the name of the global one again? What was the global one that you could go and check?
The Global Brand Database.
Oh, that's what it's called, Global Brand Database.
Yeah, it used to be called RAMARN, which is an acronym for a whole long thing. But they're only in the last few months, actually, they've transitioned over to the Global Brand Database.
Okay, well, that's easy to remember.
Yeah. And again, I think if you Google that, it'll take you to the right page. But the WIPO site's a bit more user-friendly than the IP Australia one. And you can do the same thing in other countries. So the USPTO has their own register, Canada does, New Zealand does. So they've all got their own registers. So check your country first, because if there is a registration in your country, that's going to be a big issue. And check the Global Brand Database subsequently, just to cover off, are you going to expand into other countries, or are you selling to people via your website and your products are going overseas? So it's worth doing that check as well.
Yeah, we actually, we had that a few years back because we had Walk-Right footwear registered as a trademark. And we had Walk-Right registered as a trademark. And then there was a shoe company that were trying to bring shoes into Australia, and they were called Walk-Right Footwear. And I noticed, because every 3 or 4 months, I actually just do random searches on the internet for trademarks that I have, just to see if they're popping up anywhere.
That's great.
And I noticed that there was this shoe company, and they were wanting to bring their shoes in. So I wrote to them and said, I'm sorry, but we've got the trademark. We've got a shoe store. We're selling footwear. That's our business name. That's our trademark. I'm sorry, but... Yeah, and then they actually approached us, wanted to buy it from us. And but they weren't offering enough, so we said no. And they didn't end up bringing their shoes in.
And do you know, if they hadn't have provided, an acceptable response, you can use your trademark in order to lodge a notice with the customs department, and the customs department can prevent imports of infringing material.
Ooh, that's nice to know. Most people wouldn't be aware of that, would they?
No, and look, the ones I've seen have been really big business. It's Apple or it's Sony. It's really big business that go to the extent of lodging notices with customs. But certainly that's an option that's open to any size trader if you've got yourself set up right and you've got your registered trademark.
So, but it is something, like I said, where every few months I do a search for different trademarks I have just to make sure that nobody is infringing on them. And it takes 2 hours, once a quarter, just to search things and see what's actually turning up. So that's something that people should be doing.
Absolutely, yeah. So once you've got yourself set up properly and you're protected, because this is a moving feast and because the planet is a small place now, it's always definitely a good idea to just touch base on those different platforms on social media, on Google and whatnot, and see what else is popping up. And those kinds of searches will also let you know if someone's using your trademark as an AdWord or otherwise in their Google search parameters.
Yeah.
Just to make sure you're not missing out.
So in as a brief summary, because I've got some other questions. So you pretty much with business names and all, you start at the end first. So you look at the trademark first and you work your way back through to so getting the trademark, getting the domain, and then registering your business and company name around the same time.
Yeah. As long as you cover off those 4 different options, you'll certainly be much better placed to make sure you have exclusivity of the name and to make sure that if there is a fight, you're the one holding the gun.
Okay, well, yeah, I like that. So what happens if somebody, say all of a sudden someone comes up with I've got this idea for a great business name and it's called, whatever it is, ABC, whatever.
Yeah.
Should they straight away just go and have a look to see if the trademark's registered, and if it's not, just try and grab that name and hold on to it for a certain number of years?
Yeah, well, it's certainly worth doing, particularly if it's, a really groovy name, a really unique one. And I always say to people, look, in order to get registered as a trademark, it has to be what's called inherently distinctive. So there has to be something about it that's unique. So don't use anything descriptive. If it's what are you and what do you do or sell, it'll be too descriptive and you won't achieve trademark registration. So make sure it's a bit quirky. Once you know you've got a quirky one, you can register even if you're not trading. So you can file your application, and so long as at the time of you filing your application, you are using or you intend to use your mark, the application will be allowed. And then on the back end of that intention can only last so long.
Yeah.
So there are options under the trademarks legislation for someone to remove a mark for non-use. So if it has been 5 years from your filing date and it hasn't been used, a third party, anyone, I could come, even if I'm not using it, I can come over and request that registration be removed because it hasn't been used.
Okay, so then do the trademark department then contact that person and say, hey, you haven't used it for 5 years, we're going to take it off the register, or do they just take it off?
So it's kind of like a dispute process, really. So you file your application saying if it's a brand new one, it has to be 5 years from registration.
Yeah.
If it's a couple of years down the track, it needs to be 3 years of non-use. So if you use it for 5 years and then stop for 3 years, they can apply then.
Okay.
So once you file your application, IP Australia will notify the owner to say someone has applied for removal for non-use. Do you want to defend it? If the owner does not file a notice of intention to defend, the mark immediately gets removed.
Oh, right. Okay. That's interesting.
Yeah, that's a recent change. If they do lodge their notice of intention to defend, then it's kind of like a court procedure. So one party has to file their submissions. The owner has to file evidence to say, no, here's how I used it. I used it, at a trade show, or here's my shop front, or whatever it is. And then there's a right of reply, and then essentially it goes to a hearing. So it's the same sort of process as a court process, but it's run through IP Australia rather than through a court.
But they've really got to prove that they're using it. They can't just go, oh, yeah, look, we used it on this one day at an expo last week because we heard about this proceeding, so we want to prove that we're using it. So using it once in 3 or 5 years does not really doesn't validate that it's being used.
No. There's also a little quirk in the legislation that allows you to try and resolve the issue. So the period of measurement, the 3 or 5 years, finishes 30 days before the application is filed. So the idea is you got 30 days to say, hey Tyson, I see you've got a trademark registration, but I reckon you haven't been using it. How about you voluntarily assign it to me or cancel it or whatever you want? If not, we are going to apply for removal for non-use. And then within 30 days after that, if you start using the mark, it's too late. Any use in that 30 days doesn't count. So if I write to you and say, I think you're not using it, assign it or else, and you don't respond, then on day 28, I'll file my application to remove it for non-use. And if you've used it in that 28 days, too bad, doesn't count.
Oh, right, okay. Geez, it gets quite technical, doesn't it? So if somebody, like, what about, you'll see a business name and they'll have like a quirky saying afterwards or a bit of a statement, like a unique selling proposition, something that is sort of attached to the business name. Should they also try and register that so they take ownership of that particular saying or quote?
Yes, so you can register for your tagline as well. I actually had a trademark knocked back because of a tagline that was filed sort of 30 years prior. And I thought, well, the tagline's only a small part of this ginormous mark. But no, this third-party tagline was still on the register and still valid, so it was still an issue.
Yeah, so that's what I meant. So like taglines, if you've got a tagline and you think, well, this is very unique and it really depicts what my business is all about, that is still worth going and getting it registered.
Yeah. And then you can do that a couple of ways. So you can either do it with your logo and your business name as one image, or you can do the different pieces separately. So if you've got an icon that you use on your social media, and then you've got the name itself, and then you've got your tagline, or you've got some other sort of logo. So you can do it whole as bolus, or you can do the different pieces separately. And the benefit of doing the different pieces separately is that if someone else is using your tagline, but with different name and a different logo, you can still take action because your tagline is protected separately. Does that make sense?
Yeah, no, that makes perfect sense. And what I was going to say, but if you also have you've got your business name or and you get a trademark, then you have a tagline and you go, bang, I get a trademark. If you have a unique product that you end up giving a name to, you can also get a trademark on that. Like I'd say, like an iPod, an iPad, iTunes,
definitely.
Which are all, so Apple is the big name, but all these products that they come up with, they just keep registering as trademarks.
Yeah, they have an enormous portfolio. So does Coke, actually. Their brand is really where all their value is. So they, would have trademarks for Coke and Coke Zero and Diet Coke and all of those other products that they supply.
Yeah, so they put a lot of time and effort into actually covering their ass, pretty much. Protecting their brand. It's all about brand protection.
Yes, that's right. Because if you allow other traders to start using it and leveraging off it, then the value of your brand will go down because people will think, oh, this is the same sort of product, or they don't seem to care so much about it, and there's others popping up. And once that starts happening and a bit of time passes, it gets more and more difficult to, smite them out. It's like that whack-a-mole game.
Yeah, but I'm not sure if this is correct or not, and I might be completely wrong, but I'm sure you will know, that didn't Kodak have a problem at one stage? That because, was it Kodak or another company, that whatever they were saying became such a common use word that they ended up losing the trademark because of it? Yes.
Esky is a good example of that.
Yeah, Esky was one that was coming to mind.
Band-Aid. So if and this is usually an issue for companies that have new products. So like a new patented product. Trampoline is another one. So
we'll just point out to people in different countries, and esky is like a cooler, or if you're in New Zealand, it's a chili bin. Just so you just want to break down the barriers. I speak all languages.
Yeah. So they had markets, and you'll notice next time you're looking at your box of Band-Aids or self-adhesive strips.
Yeah.
The Band-Aid was the brand name for little, sticky strips that you put on when you've cut yourself. So now, because there was a risk of that brand being, becoming generic, the boxes now say Band-Aid self-adhesive strips. Okay. And then other providers of self-adhesive strips have to use their own brand, but can write self-adhesive strips.
Okay, so is the problem where somebody will come up with a cool trademark, And because then everybody is starting to use it in common language and they're not stopping people from using it, that it then...
It can become
loses
generic.
it becomes generic and it loses its power.
Yeah, so we often call this death by genericide. So it's become so generic that we don't know how else to name this product. So we can't give exclusivity of that generic name to one party. We need to take it away so other parties can use it.
Yeah,
Someone tried to run this argument recently with Google.
Yeah.
You know, when you say Google it, which I've totally said within the last half an hour, Google it. So a user had tried to argue that Google had become generic because everyone was saying Google it. And this, I think this dispute was held in the US actually. And there the decision maker had said, well, I see where you're coming from, but when people are saying Google it, they're saying go to Google and search it. They're not saying go to Bing or go to Yahoo or any other search engine.
Yeah.
They're saying still go to this specific one. So Google was able to save itself there.
So with IP and with trademarks, basically the more IP you have within your business and the more trademarks that you collect long term, it actually holds value for that business and actually equals money.
Yeah, that's right. So one of the most obvious reasons for having those registrations in place is to make sure that if there is a fight, you're holding the gun, you're set up well to protect yourself. But in addition to that, that's sort of like your insurance policy approach. In addition to that, you know, a trademark, registered trademark is personal property. Banks will lend on the basis of valuable marks. That's how a lot of banks lend to franchise systems. A trademark is essential if you're going to franchise your business because that's the main part that you're sharing with it. There is value in those registrations, so you can earn more for your business on sale because you can say, you know, here's the IP that goes with it.
Is that like, say you're going to go and open up you want to sell hamburgers. You go to the bank and say, I'm going to open up a restaurant that's going to sell really high-class hamburgers. And they go, yeah, okay. Or you say, I'm opening up a McDonald's.
Exactly.
The bank straight away goes, we recognize the brand. That brand has value. We know you put a McDonald's sign at the front of your business, it's going to attract more people than if you put Ben's Burger Barn. So the bank is more liable to lend you money because it sees the value in the trademark.
Yeah. And when you go to banks, so I did a presentation with a chap from ANZ Bank, and he already had a list to say, if you're entering these franchise systems, we are already confident enough with the name that we'll give you the money. And it is the likes of Macca's, KFC, Subway, I think was on the list.
Yeah.
So it's big names because there's so much value in those brands and therefore so much value in joining those systems.
Okay, so for the average small business owner, so now they know if they don't have a trademark for their current business name, they need to get off the bum and go and do it. How do people contact you? You know, Donna, if someone says, okay, this Donna sounds like she knows what she's talking about, and I can vouch that she does know what she's talking about, how do people get hold of you so that they can actually ask you these questions or get some trademarks done? What would be your suggestion?
You can hit me up across the different social media channels. So on Facebook, Donna Patane, on Instagram, Twitter, Donna Patane 5. You can always email dpatane, Patane, at McDonald's, McDonells.com.au.
Okay, not the McDonald's with the big arches.
No. And it's spelled totally differently. And we have a trademark.
You do have a trademark. That's good. Yep. Now, you'll hear some people say, well, okay, they need to get a trademark. Should they always do it through a lawyer, or is it something they can do themselves online?
Probably a bit here and a bit there. If you just want to hand it over and have someone take care of it, by all means, you can have a lawyer do that or a trademarks attorney. And they will do your pre-application searches, fill out your application details, which you just need to check off, file the application and take care of the process.
Yeah.
If you want to keep your costs down a little bit, do those first bits yourself. So do all your pre-application searches, checking ASIC, the business names, the domains, the trademarks register, check yourself off on those. You can prepare some of the details of your application yourself. So, you know, your name or the entity that owns your business, your address, and then your goods and services. So I'm going to go sort of tangent here. When you apply for trademark registration, you need to specify in your application what goods and services you supply and what you're using that trademark in association with. Now, across the planet, because these are set by WIPO, there
Yeah.
are 45 classes of goods and services. So anything you can think of to sell or to provide, service or good, is within those 45. So you need to find which classes you're in. So, for example, our registration is in class 42 because it's legal services, and it's in class 35 because that's education and legal education and that sort of thing. So you got to go through the 45 and pick which ones you want. If you're selling widgets, you'll be in the first 31. If you're providing services, you'll be in the back end.
Okay, so does that mean that if you can have the same trademark registered, two people can have the same trademark but in different categories?
Yeah, could do. So the system works such that you can't have two marks that are substantially identical or deceptively similar in relation to the same or similar goods or services. So I suppose that's how my firm can coexist with Macca's The Golden Arches.
Yeah.
The spelling's a bit different, but in addition to that, they're providing fast food and we're providing legal services. So in the marketplace, there isn't a crossover.
But if McDonald's Law decided to start selling hamburgers, there could be an issue.
We'd have a problem, yeah.
Okay, and McDonald's decided to start providing legal services, they could have a problem.
Yeah, there is a little quirk in the trademarks legislation, which is similar across Australia and the US. The US is actually a little stronger in this sort of respect for infamous marks. So for marks that are so well known that no one can provide any goods and services with it. So I suppose Google or Sony, or names that are so big that if you want to provide Sony burgers, there's still going to be some sort of issue, and IP Australia or the registrar will probably prevent registration. So when they're infamous, even if they're registered, in relation to burgers, they may be able to still take action outside of that class because they're so famous.
Okay, have you got any parting advice? Well, actually, I always ask everybody one question to finish up the interview with. I haven't even warned you about this.
No.
But I know you can talk underwater, so this won't be a problem. So it's Monday morning, and there's a small business owner, and they're walking down the street, and they bump into you out the front of a McDonald's law firm, and they go, "Donna, I listened to you on a podcast on It's No Secret with Dr. T. What's the one bit of advice you would give me today that I should, when I walk back into work, that I should do?"
Absolutely. First thing, hands down, get on IP Australia's website and the global brand database and check your name. Make sure if you haven't yet registered it, you can, and it doesn't already belong to someone else.
So are you saying check their business name? Basically go straight on there, check your business name, make sure nobody else has it, and if they don't have it, get your finger out and actually go and get it registered.
Yes.
You wouldn't say get your finger out because that's not really a law term.
No. I probably would say please do something about it. Because I would much prefer to help someone else getting their registration than to help someone else defending, trying to keep their business name. I would much prefer be on the proactive side, getting things protected, or hell, sending nasty letters to other businesses than to be on the receiving end.
Okay, I think that's a really good point to sort of close on, is making sure that, like you said, be proactive, not reactive afterwards, where all of a sudden you're being accused of breaking somebody else's trademark.
Yeah, and I guarantee it will be cheaper every time to be proactive than it will to be reactive and defending.
I think that is fitting advice and a great way to end this conversation today. Donna, I want to thank you for sharing your knowledge on trademarks, and I reckon anyone that listens to this today, if you don't have a trademark, go out there and just get your business name, get it registered, contact Donna. I have nothing else to say other than thank you, Donna, for being on It's No Secret with Dr. T.
Thanks very much for having me.
Well, I'm sure after listening to Donna today, you're going to be rushing out and making sure that your business name and any other IP that you've been developing has a trademark and is protected. Because like the title of this episode said, don't take a sword to a gunfight. And that's what you're basically doing by not protecting your IP and not protecting your business name. You're going to be vulnerable to somebody else registering it before you, and you may be losing the power and value of all that hard work you've put in behind your business. So my guest next week is Captain Jim Palmer. Now we call him Captain because he lives on a boat. He is living the dream. He's also known as the newsletter guru and dream business coach. He's also the author of 7 books. Here's a little snippet of what's coming up next week.
you're going to have different client base. It's not to say that's wrong, but I think it's easier when you launch another business that can be served by the same list of customers you already have, because it's the know, like, and trust factor. The hardest thing, the most expensive, most time-consuming thing for any business is customer acquisition. So once you acquire that customer, just find different ways to serve them, because they already proven that they know, like, and trust you by becoming a customer in the first place.
Now, I already know you're going to really, really enjoy the information that Jim Palmer shares next week, but you may have picked up already, there's a little problem with the audio, but just bear with it. The information is gold. Now, if you have any thoughts after listening to this episode, I'd love to hear from you. You can leave your comments on my website, tysonfranklin.com, or you can reach out to me on Facebook and LinkedIn. Just look for Tyson E. Franklin. Otherwise, just track me down on Twitter and Instagram, Tyson Franklin 66. And if you're enjoying this podcast and you like the content it brings to you each week, if you get the chance, just leave us a review on iTunes or one of the other podcast platforms. Even a 3-star review is better than no review at all. And finally, share the love. If you have friends and you think they'll benefit from listening to this podcast, pass it on to them. Tell them, check out It's No Secret with Dr. T. Okay, that's it from me. Take care of yourselves, look after your family, and I will talk to you again next week. Bye for now.